Sir. Hello, everyone. I'm Ivana Petriconi. I'm the Executive Director of the Arch Disability Law Center, and it's my great pleasure today to welcome you to the Access Awareness Symposium for this year. We have an annual event in partnership with the Law Society to celebrate the equality rights of people with disabilities, and I'm delighted that we're here again this year. The Law Society is a great partner for Arch, especially the Equity Department, and they make this very easy for us to put on. So I'd like to special shout out to the Equity Department. We're also very happy today to have with us a bencher of the Law Society, Mary Louise Dixon, who's going to bring us some greetings from the Law Society. Mary Louise?
Thank you very much. Good afternoon and welcome. On behalf of Treasurer Thomas Conway and the Law Society of Upper Canada, I'm pleased to welcome you to celebrate our annual Awareness for Access event. I think we've done this for a number of years, and I'd like to extend our appreciation and thanks to Arch Disability Law Center for partnering with the Law Society to produce and host today's program. I also wish to welcome and thank all of our speakers for being with us today to share their knowledge and expertise. Each year, the Law Society and Arch Disability Law Center host this event to promote dialogue and increase awareness about disability issues. Our primary goal is to promote the understanding of law as it affects people with disabilities in order to increase access to justice. As the regulator of Ontario's lawyers and paralegals, an important part of the Law Society's mandate is to advance the principles of equity and diversity in the legal profession and to promote access to justice. Over the years, the Law Society and Arch have embarked on a number of initiatives to address issues and challenges faced by persons with disabilities. In 2004, a working group on disability issues was formed at the Law Society, comprised of governing benchers and staff, members of the profession, including lawyers with disabilities, and Arch Disability Law Center. A consultation process with students and members of the profession was conducted to identify the types of support that are necessary to help persons with disabilities enter the legal profession and to help lawyers with disabilities advance in their legal career. In addition, a number of initiatives have been implemented to support persons with disabilities, including the Equity and Diversity Mentorship Program, model policies on accommodation, and development of accessibility standards. And most recently, the work we've been doing to meet the requirements of the Accessibility for Ontarians with Disabilities Act. I'm also pleased to be a member of the Ontario Courts Accessibility Committee, working to make our court system more accessible for people with disabilities of many kinds, including hard of hearing, blind, and the other range of disabilities. Today, we are pleased to have a panel of legal practitioners and community advocates to examine this year's theme entitled Achieving Autonomy and Inclusion for Racialized People with Disabilities. It is also timely that this year's program addresses both disability issues and racial bias in its discussion. We have recently embarked on a major initiative to consider strategies for enhanced inclusion of racialized legal professionals at all career stages. As a result, we are about to conduct a series of focus groups with racialized lawyers and paralegals. Following the discussion, I hope you will stay for the cocktail reception and network, have some refreshments, and enjoy the good food and company. In closing, I'd like to take this opportunity to recognize Arch Disability Law Center for its tireless efforts in providing its services to members of the disability community. I know myself that it has worked for many years in this area and has made a difference. Congratulations to all the staff at the clinic for all your hard work. I also wish to thank Arch for partnering with the Law Society's Equity Initiatives Department for organizing today's events. Finally, thank you all for joining us for this important occasion. I extend my best wishes for a successful event and celebration.
Thanks very much, Mary Louise. So I'm just going to give you a little outline of our program today. We're going to have 3 panels, and then if you sit through all our 3 panels, there'll be a lovely reception here, I promise, at 6:30, which I hope you can all stay and join us in. The presentations will deal with areas of the law which affect many racialized people with disabilities. We've chosen immigration and family law as focuses for today because people with disabilities encounter with these areas are often made more difficult, more complex as a result of the disability. The program will examine scenarios in family and immigration law, and it will be of particular interest to lawyers and paralegals who practice in these areas. But it will also be of interest to anyone who wants to provide effective services to people with disabilities. And in particular, we hope that it will assist lawyers who need to meet legal and human rights obligations to persons with disabilities. Many areas of the law impact persons with disabilities, so an improved understanding of a lawyer's responsibilities to clients with disabilities will assist the profession in providing services in other areas of law as well. Arch is particularly interested in increasing the ability of private bar lawyers to provide services to our community. We practice in 4 areas of priority, as I think many of you know. Those 4 are attendance services and the right to live independently, the rights of people with intellectual disabilities, education or the rights of students, and legal capacity. And we also just want to take a moment, because many of our colleagues are here from other clinics, to emphasize that a large part of the work of all community legal clinics is to serve people with disabilities. In fact, it's a large part of the work of clinics. And clinics are frequently at the forefront of advocacy for people with disabilities. Arch could not do all of the disability work in this province. Issues of income support, ODSP, and housing are among the most pressing that face the community of people with disabilities who have low incomes. Still, we all receive many calls from individuals whom we can't serve and for whom we don't have adequate referrals. This is because many of the areas of law that affect people with disability are not practiced at Arch or in the community legal clinics. And some people with disabilities have incomes that are higher than the Legal Aid Ontario eligibility cutoffs. So Arch is trying to develop a broad list of lawyers practicing in all areas in which clinics seek service to address gaps in the legal resources for people with disabilities. We want to include lawyers who will receive referrals from our clients. Some will be able to pay, but of course we would also welcome those lawyers who are willing to provide some pro bono hours. We understand that lawyers who practice in this area and who will participate in our referral network will require resources and support. So Arch is providing this continuing professional development program. We provide others throughout the year, and they are open to the public and to the legal profession. So participating lawyers are invited to join Arch's referral list. If you would like to do so, there are some forms at the back of the room, or I guess I'm at the front, you're at the back. So outside of the room at the registration table. And for those who are viewing us on the webcast, the forms will be available on Arch's website, so feel free to contact us directly if you have further questions. So before I introduce our first panel to you, I have a few little housekeeping items to speak of. There's a video being made. It'll be filming the front of the room. So if you don't want to be in the video, just stay behind the cameras. They're here. We'll take questions at the end of each session and just ask that we try and keep to the time limit. We started a little late because of the weather being nasty out there, and we do want to get to our reception in time. So if you could just keep your questions short, that would be great. And of course, we're hoping that our panelists will stick around for the reception, so you will have access to them to have a conversation or to ask further questions. I just wanted to point out our access team. So there are attendants at the back of the room if anyone requires an attendant. As you can see, we have the cart services that are typing up here behind me, and the ASL interpreters. And I have a special request from our friends to please speak slowly, and especially if you're reading, because sometimes they can get a little behind if we rush too fast. There are Braille programs at the back if anyone would like one. Okay, so I'm going to introduce the first two panelists, Diane and Aisha. Would you like to come up to the front of the room? So our first panel will give an overview of our program today. And on the panel are Diane Wintermute. Are you on this panel too? Okay. Diane is a staff lawyer at Arch. I hope that many of you know Diane. And Aisha Musleh, a friend of Arch, I like to think, who is a disability rights advocate who's joining us today from her position at McMaster University, where she's the Accessibility Specialist, Human Rights and Equity Services. And Ed Montagny, who I should say is one of the two Arch staff primarily responsible for putting on this event. Ed, along with Yadida Zalik, have put the program together for you today. Ed is going to be monitoring the panel. Okay, thanks very much.
one of those people who actually speaks quite quickly, so you have my permission to give me a little nudge if I start speaking too fast. In my talk today, I'm going to give you a very brief overview of issues that could arise when a client's capacity to instruct counsel are in question. There's a lot written on this topic, and it's often difficult to apply the capacity rules in a practical way. I hope to be able to provide you with some points to assist you if you are asked to address a situation where you're not sure whether your client has capacity to instruct or not. First, I will look at the Law Society's rules of professional conduct. Next, I'll address the test for determining capacity and its application. And finally, I'll talk about the issues of accommodation that can be used to enhance decision-making capacity. So, the Law Society rules. Many, many years ago, when I was in law school, my first year criminal law professor's mantra was, "How do we know what's a crime in Canada, Ms. Wintermute? We always go to the code. You have to go to the code." However, as a practicing lawyer, when we want to know how to conduct ourselves in an ethical and professional way, we should always go to the rules of professional conduct. Always go to the rules. Rule 2 of the Rules of Professional Conduct of the Law Society of Upper Canada provides significant guidance to lawyers and paralegals on working with clients with disabilities. And in particular, it provides, when a client's ability to make decisions is impaired because of minority, mental disability, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-solicitor relationship. The commentary to this rule provides, a lawyer and client relationship presupposes that the client has the requisite mental ability to make decisions about his or her legal affairs and give the lawyer instructions. A client's ability to make decisions, however, depends on such factors as age, intelligence, experience, mental and physical health, and I'm going to stress this because accommodation is built into the rule, and on the advice, guidance, and support of others. Further, a client's ability to make decisions may change for better or for worse over time. When a client is or comes to be under a disability that impairs his or her ability to make decisions, that impairment may be minor, or it might prevent the client from having the legal capacity to give instructions or to enter into a binding legal relationship. Recognizing these factors, the purpose of this rule is to direct a lawyer with a client under a disability to maintain, as far as possible, a normal lawyer and client relationship. So Rule 2 directs lawyers to maintain a normal solicitor-client relationship to every extent possible. And as I mentioned earlier, the rule specifically requires accommodation in order for you to do so. So if a lawyer has concerns about a client's capacity to instruct, what does that mean? And what should the lawyer do to ensure that her relationship with that client is as normal as possible? So this brings us to the test for capacity, which is my second point. One of the most frequent calls that ARCH gets from other lawyers is how to assess whether or not someone is capable of giving instructions. This is not an easy answer because it depends. There is no bright line where on one side a person is capable of giving instructions or making decisions, and on the other they are not. The accepted definition of capacity to instruct counsel is a two-part test. First, does the person have the ability to understand the information necessary to making a decision? And second, does the person appreciate the foreseeable consequences of making that decision? When applying the test for capacity, there are 4 key points that I think we should keep in mind. First, the same test applies to everyone. Second, capacity is fluid. Third, capacity is task-specific. And fourth, context is always important. So, with respect to number 1, The same test applies to everyone. A lawyer must never assume that a disability renders a person incapable of making a decision. Often people with certain disabilities, such as mental health, addictions, cognitive or intellectual disabilities, or those who use alternate forms of communication, are frequently victims of stereotypes or assumptions about their capacity to instruct. Lawyers must be vigilant against making any assumptions about the impact of disability on decision-making capacity, because to not do so would have the effect of denying someone access to justice, independence and autonomy, and the right to participate in their own legal case or issues. At ARCH, we believe that capacity to instruct counsel is a fundamental right of a person with a disability, and making appropriate accommodations to enhance the decision-making capacity of a client is required of all lawyers. Second, capacity is fluid. It's not static or absolute. Disabilities that might have an impact on capacity are those that may be invisible, episodic, or recurrent. Capacity can fluctuate, and people may be capable one day, but not the next. It's therefore up to a lawyer to assess capacity throughout the course of their interactions with a client. However, the fact that a person's ability to make decisions may fluctuate is not a reason to find that they lack capacity. A lawyer's role is to ensure that the person is capable of making a decision at the time the decision was made. If a person later becomes incapable, that does not invalidate a prior capable instruction from the client. The lawyer must be able to prove through detailed notes that they turned their mind to the issue of capacity and determined that the person was capable at the time the decision was made. Third, capacity is task-specific, which means that the legal issue the client brings to the lawyer is of particular importance in assessing decision-making capacity. Various tasks require various levels of different capacity. So a person may be capable of making decisions on some legal issues, but not others. For example, someone may be able to revoke a power of attorney, which may not be a very complex task, but may not be able to manage their property, which requires some understanding of one's finances and the ability to ensure that financial obligations are met on time. Fourth, context is important. Living in poverty has a significant impact on persons with disabilities. Levels of education, stable housing, life skills, work experience, culture, racialization, and social and personal experience play significant roles in people's lives. People with disabilities are often subject to stereotype, stigma, and attitudinal barriers that can cause isolation, segregation, and devaluation of them as individuals or participating members of society. This can lead to self-stigmatization, the result being that some people with disabilities may not be comfortable in asserting their rights or even believing that they have any because they feel so far outside of the mainstream. The role of a lawyer in these cases is to ensure that the appropriate accommodations are in place to facilitate receiving instructions from anyone with a disability, which brings us to the issue of accommodation. In order to enhance client autonomy, including the freedom to make choices, and to assist clients in living their lives as independently as possible, a lawyer must provide appropriate accommodations in order to facilitate a client's capacity to instruct. The Ontario Human Rights Code requires that anyone providing services, and this includes lawyers, has a duty to accommodate persons with disabilities. And the courts have made it clear that accommodation requires an individual approach. Despite the type of disability that a person has, their accommodations may not be the same as someone with the same disability. In other words, one size does not fit all when accommodating a person with a disability. There are a number of things that a lawyer can do to make sure that she's providing proper accommodations. And although I only have time to list a few, I think one of the most important things that you could take away today in terms of accommodation is that you must be creative. Think outside the box, because if we follow the import and intent of Rule 2, It's our job to do everything that we can to enhance a client's decision-making capacity and maintain that normal solicitor-client relationship. Failure to do so could undermine the equality rights of people with disabilities and will certainly create barriers to their full participation in society. The most important thing that a lawyer can do is ask, at the outside of the initial client meeting, whether the client has any accommodation needs. People are often reluctant to ask this question because it seems intrusive or too personal somehow. But it's worse to let the issue go unacknowledged. And in many legal cases, we ask clients far more personal questions than that. Consider whether the client needs breaks during the interview. Would they like a glass of water or something else to drink? Would they like a piece of paper and a pen to take notes? Have you created a welcome environment where there's room for a mobility device? How would the client like to be addressed? How would you like to be addressed? There are all kinds of things that a lawyer can do to make the first interview as comfortable as possible for the client in order to establish a good rapport from the outset. Making assumptions about the client's needs is not one of them. A lawyer must also remember that clients with disabilities, like everyone else, communicate in different ways. So it's up to the lawyer to find a way to promote effective communication with a client. Using plain and clear language is a must, even though most of us are taught in law school that outdated Latin or other terms are more impressive. Let the client know that if the lawyer is speaking too quickly, they should feel free to interrupt, or ask the lawyer to slow down, or repeat or explain something. If someone else wants to accompany the client into an interview, speak with the client privately first to make sure they agree with this. Sometimes the person accompanying the client could be the very person your client wants to speak to you about. If there are ways to facilitate a lawyer speaking directly with her client, then that is the preferable route. If you're using an interpreter, make sure that the interpreter does not know the client and vice versa, so there's no bias in the interview. And direct your questions to the client, not the interpreter. It's the client's response that is important. In fact, your conversation with the client should be like any other communication with a client, direct. You want to build that rapport with the client, not with the interpreter. A lawyer must be clear about her role from the outset. The lawyer's role is to provide options, advice, and opinions. The issue or case and the decisions to be made with respect to that case belong to the client. Ensuring that the person with the disability knows that they are instructing a lawyer based on legal opinion and advice is empowering for the client. And remember, you don't have to have a disability to make a decision that a lawyer doesn't agree with. We can and have all made decisions we may later regret, and that's a prerogative. Ask clear and open-ended questions, but if a lawyer needs to explain context about why those questions are important, then explain. Remember that when determining capacity, the scope of the inquiry is task-specific. Who cares who the Prime Minister of Canada is if that's not relevant to the case? A lawyer must also evaluate her own biases and misperceptions about disability and capacity. A lawyer must always presume capacity at the outset of the interview. Someone does not have to have a disability to be in a crisis situation. Most clients who see lawyers are in some kind of crisis, but it's far too easy to blame some behaviors on clients with certain disabilities. Remain calm and professional, as with all your clients. De-escalate the situation by using a calm voice, taking a break, or asking what the lawyer can do to help. In some cases, I've also used special retainers, which could include clauses like, I agree not to call after hours and leave messages. If the information I have is important for my lawyer to hear, I will call during business hours and speak with my lawyer so we can have a discussion and I can provide the reasons why I think the information is important. Sometimes a retainer that sets out small steps to be taken as opposed to one big, large global one that is your end result is more easy for a client to understand and helps you to ensure task-specific capacity. If you're still unsure about the client's capacity, get a second opinion. Arch lawyers are always available for a lawyer-to-lawyer consult. Now, there were two other issues that I was going to mention. One was the use of support people, and I will just briefly say that sometimes a client will feel more comfortable with with a support person in the room, but that person doesn't have a right to be there. Make sure that you speak with the client privately and get their consent before inviting a support person into the interview room, because you never know whether the support person is actually the person that the client wants to talk to the lawyer about. The other was supported decision-making, and I think I'll leave that issue for another time. It's a concept that's in its infancy. It's still being tested, and there's lots of literature that's available on supported decision-making and facilitating communication with a lawyer. And then after Aisha's presentation, we'll be happy to answer a few questions, but we'll be around during the refreshment break if you want to talk to us some more. Thanks.
Good afternoon, everyone. As you may or may not know, I'm Aisha Musla. I'm currently, my current title is Accessibility Specialist at McMaster University. However, my previous, that's just been my job for like the last month, so I'm still transitioning from the position of a community worker and advocate to, I guess, another country we call university. So most of my comments are going to be based on my work that I've done as a community worker. My last 2-year contract was with ERDCO, the Ethno-Racial People with Disabilities Coalition of Ontario. And we did a project around the AODA and training settlement workers around the experiences and how to service newcomers with disabilities. Just to give you a little bit about myself, I like to give context and positioning of my own experiences first, so you know where I'm coming from, and I encourage everyone to do that even in your everyday work, that you place yourself within context and look at where you're coming from and how, as Diane was speaking to, look at your own biases and how you interpret the situation in front of you prior to making decisions or approaching a circumstance. So I am not an immigrant. However, I am a child of immigrants from the Middle East. I was diagnosed with a visual disability at the age of 9, although my condition is congenital. And how that impacted me as a child was that I had difficulty learning how to read, participating in class, and you know, at the time, my parents didn't know how to challenge. They knew something was wrong, but the class and schools were telling them that I was not a very bright person. So my mother, who was my biggest advocate as a child, insisted that there was something else wrong, and we finally, at the age of 9, got an official diagnosis. But that wasn't the end of the experience. Again, for my parents, and I'm going to put it in the context of my parents, didn't know what was being told of them. The school system provided us with quote unquote, and I'll put air quotes, accommodations, but my parents didn't know what to ask for, and I as a child was never consulted. And so, I mean, I think these kind of experiences can be translated even today, where families who come into Canada don't know what to ask for and don't know the system here. And the work that I've done over the last 2 years has substantiated that often immigrant families who come to Canada seeking settlement services don't know what their entitlements are, what they qualify, what their eligibilities are, what sort of funding is out there, and then when they do finally find out that information, then there are long-term waiting lists. I'm not a lawyer, so I'm not going to be speaking in legal jargon or any of that sort of stuff. But my primary concern here is essentially with the experiences of the on-the-ground experiences and everyday experiences of people with disabilities from racialized communities. When people with disabilities or their family members come to Canada, they often face many barriers, such as language barriers, access to education. Actually, I'm going to focus on language barriers. There is more to the direct translation to services, like translating that we have A, B, and C services to individuals who come to Canada without having that knowledge or understanding of what this means and for their family member often leads to a lot of misunderstanding. And I'll just give you an example. There was an individual when I was doing my training, he spoke to me about how this family with young children, a young child with a disability, required specific services. Their parents denied the disability, and that they saw this issue of denying disability as being the person's individual, the family's individual barrier to getting services. However, placed in context, the culture itself doesn't acknowledge disability in general. The culture itself, when presented with individuals with a disability, ignores that person. So often, what we don't consider are the stressors that people come across. In order to acknowledge disability, there needs to be welcoming environments to disability and inclusion of not only non-disabled members, but disabled members. So that's next around language, then access to services. As I indicated, often people with disabilities who are immigrants do not know what the services are available to them, the eligibility, and then the wait list. Then also what we came across is the mental health stressors that often people come in that they experience. And all of this culminates into the inability for people to access services, but also to integrate fully into Canadian society in general. Often what we don't realize is that people who individuals may come from war-torn areas. When they come here, again, mental health stressors, but they may not be able to acknowledge that experience. So it takes a long time for people to acknowledge possible, especially if a disability has been acquired over time. Sorry, I've lost my train of thought. Basically, what I'm trying to get at is, when we bring in people with, when we're servicing people with disabilities in general, that we need to understand the full context to which they are entering our space. What we can do are very proactive pieces of understanding and asking the appropriate questions to the individuals, asking them to to ensure that they themselves are taking the lead in their own process of whatever that service happened to be, whether it be legal services or social services, access to education, and so on. That that we also are able to understand the ways in which we approach a situation may impact on the individual's ability to confide in or to address a situation directly. Sorry. So on the other hand, what I would also like to emphasize is that not only do people with disabilities in the larger Canadian context experience barriers to services that don't necessarily take their entire person or their holistic person into consideration, but that also when people come that when we, I'm not sure why I'm losing my train of thought right now, I'm sorry. That when we in general, what I'm trying to say is that often here we are looking to like institutions and lawyers that are registered with the Law Society, that are practicing lawyers, and other services that are quote unquote mainstream. But at the other side of that, I would say that often racialized communities have not addressed the issue of disability in general and in the work that they've done either. That there is a gap not only with general services that are targeted towards the general population of Canada, but that also on the other side of it, the coin is that disability, and I would say that also the mainstream has not addressed the issue of race in its entirety, and that race and racism have and still remains to be a very tenuous issue to address. And I feel that when the conversation, if it's not couched in very specific language, people get their backs up, and that it is very difficult for people to combat and to address in general. But on the other side of that is that racialized communities has not substantively addressed the issue of disability, that often, and I'll use my cultural background as an example, that although other communities have service provision that is targeted towards their communities with such as Hunfolk's mental health services, which I believe is going to speak later on today, and Across Boundaries, which takes a generalized approach to mental health and racialized communities, like they don't specifically deal with one community. That in general, the conversations around mental health doesn't exist. The conversations around developmental disability and inclusion and access does not exist within that context either. And I think that unless both sides address the issues, that the gaps in the conversation, that it's going to be, it will be a difficult track forward in trying to create accessibility for all people within Canada. And I think that agencies such as ERDCO and Across Boundaries and Hunfolk are specifically looking to create inclusive environments, people where they have shared experiences, but then can go into the general society and be included and participate to the fullest of their ability. And by ignoring or negating, or not negating necessarily, but ignoring the fact that people are holistic people, that they have a multitude of identities that impact and on their experiences, for instance, race, disability, gender, class. And I think Diane made so many great points. I think I should have gone before you, actually, just to provide a little more social context to the context that Diane had provided with specific legal approaches that people's experience, people's abilities to advocate for themselves or to integrate depends so significantly on where they come from. So if they came from a family that is well off, that has access to education, regardless if they have a disability or not, they may fare much better than somebody that comes from a poor income with a lack of access to healthy foods, education, proper housing, places to go to socialize, etc. So, okay. Basically, I think that when we want to look at the circumstances to which racialized people with disabilities experience, it's not just looking at the one dynamic, and I think that's one thing that ERDCO and myself advocate for, is that we need to take into consideration the entire person, the role of the family, the role of their gender or the impact of their gender on them within their cultural context, whether they were born here in Canada. Language is so significant. If I were here as an immigrant and English was my second language, how much would I be within my career versus when English is my first language? My connections are here in Canada, and so I would be better able to succeed in this society versus somebody that is coming here anew, trying to find opportunities, who may have all the ambition in the world but doesn't understand the system, doesn't understand, doesn't have access or connections here. And so when providing services, including legal services, I think that we need to be able to fully understand the social context to which people come and enter through our doors, and that should guide what you do in general when servicing people with disabilities. Thank you.
We can now take 2 or 3 questions, and say if you can keep them brief and maybe address which of the speakers you're addressing the question to. Person at the far back first and closer up.
Try to speak up. So this is a question primarily, I guess, for Ms. Whitman. I'm a lawyer for Children's Aid Society, and the rules require that all lawyers who may note that someone, a party, may be under a disability and may need some special representation, like the public guardian and trustee, has an obligation to raise the issue. It's not just solicitor of record, any lawyer interacting with that party. What happens when we find resistance from that party? Because, for instance, in child protection proceedings, where that kind of designation may at some point disadvantage them down the road when they're trying to get their children back in a child protection proceeding, having been designated as a person who might lack capacity or might have special needs in that way may disadvantage them. So how do you suggest we interact when someone might be resistant? And we don't want to be paternalistic yet, and we won't, but we might feel protective. But you don't want to offend someone's sense of autonomy and their right to control their destiny.
Right, and just for the video, summarize the question a bit. It was that in some family law scenarios, if you have to officially designate or raise a capacity issue, once someone has been identified as having a capacity issue, might that work against them in the future, and how do you avoid that?
Well, I'm hoping that the family law panel will deal with that question more specifically, but I mean, you raise a really good point. I think that there are a couple of ways that you can raise the issue of incapacity without undermining the dignity of the person. And that's to be frankly, as direct as you need to be, and not sort of pretty it up at all. I think it's more demeaning to talk down to someone than it is to be straightforward and just say, I have these concerns. You're entitled to have a capacity assessment. You're entitled to, whatever other routes are available to you. But my advice to you would be, and then if the person rejects the advice, at some point, I suppose, there's a lack of confidence in the advice that you're providing, and you follow that route. Ed, do you have anything to add?
So I hope the family law panel will be able to expand on that. There's another question.
Hi, first of all, thank you to Arch for doing this event. It's really, really educational and informative, and thank you to the panelists. I wanted to maybe ask Aisha, who I know is a very, very dedicated advocate for persons with disabilities. Do you think that the issue of privilege has also something to do with the fact that we're not necessarily addressing the the barriers, the attitudinal barriers for persons with disabilities? You mentioned that sometimes it doesn't matter if you have a disability, but if you're well off, it's easier to navigate it. So then, what about the privilege of race, the privilege of education, the privilege of money?
Does this work? Oh, I feel uncomfortable with this thing. Oh, yeah, I can pull it closer? Okay. Absolutely. I think that obviously if people have access to education, to money. I think I did mention the issue of class and all that the class and education, access to every aspect of society privileges individuals, and that for the most part, if you come, depending on your immigration status, your family status here in Canada, it does impact on an individual's ability to integrate. I'm focusing on immigrants because that's what I understand the theme to be, but I think you can also apply that to racialized people that are born and raised here in Canada, that there is a legacy of oppression does not allow them to fare as well as those who may come from more, or would say white communities or European.
Right, so if there are no questions, we'll have more time at the end as well. So maybe once we have the other panels, certainly we can address other issues. So at this point, I'll invite the next panel on immigration law and policy to come up. Tess Sheldon, Tom Pham, and Carol Simon Dahan.
Hi there. So my name is Tess Sheldon, and the purpose of today's session is to illustrate just one of the ways that race and disability intersect. And to do that, we're going to use an example, the experience of people with mental health issues from racialized communities as they are confronted by the immigration system. So we're delighted to have two speakers to introduce you to the range and kind of legal issues that arise in this context. So we're going to first hear from from Tom Pham, who is the team leader of the Intake and Case Management Team at Hong Fook Mental Health Association. So we're especially grateful to Tom for making time to join us at the very last minute. We did have another community advocate scheduled to speak on this panel, but unfortunately they weren't able to make it. So what this means is that Tom's bio is not included in your package, so I'm going to take a moment to read it to you in full. Okay? So Tom came to Canada in 1983 from a Vietnamese refugee camp in Southeast Asia. He attended high school in Toronto from until 1987. He completed his Bachelor of Arts in Psychology at Lakehead University in 1990. He completed his Honours Bachelor of Social Work at York in 1995 and his Master's of Social Work at York in 2006. He's been a registered social worker since 2001. He is the past president of the Vietnamese Association in Toronto, the past president of the Vietnamese Youth and Family Social Services, and he's served as a board member at Access Alliance and Metro Toronto Chinese and Southeast Asian Legal Clinic, and other not-for-profit and charitable organizations. And he's been with Hong Fook Mental Health Association since 2002. He reads, speaks, and writes fluently in the Vietnamese language. And as a Buddhist follower, his favorite quote from the Sakyamuni Buddha's teaching is, "Thousands of candles can be lit from a single candle, and the life of the candle will not be shortened. Likewise, happiness never decreases by being shared." And our second speaker, who we're also delighted to have with us today, is Carol DeHaan, and she's the director of the Refugee Law Office, which is a staff office of Legal Aid Ontario, where she practices immigration and refugee law, and you'll find her bio in your materials. So I'm just going to get us started with a brief introduction into the kinds of legal issues that come up in this context for ARCH. And as you might know, ARCH provides a telephone summary advice and referral service to Ontarians with disabilities. And through that service, ARCH hears concerns about the experience of people with disabilities, including people with mental health issues, who confront the immigration system. And one of the questions that comes up is the accessibility of the Immigration and Refugee Board itself. And this comes up specifically around the appointment of a designated representative. And a DR, designated representative, when they're appointed by the IRB, are meant to assist parties with capacity issues, and their role can look something like a litigation guardian, but it doesn't always have to. ARCH has undertaken some litigation and law reform work around the appointment of designated reps at the IRB, and we've argued that the appointment of a DR is necessary for the fulfillment of the IRB's obligation to accommodate parties with disabilities before it. And we've also argued that the IRB can't wait passively for information about a party's mental health issues to come to it, that instead the IRB has to actively inquire about the party's disability-related needs, including related to their capacity. And this is particularly important to members of racialized communities who may fear the stigma associated with a mental health diagnosis, and indeed there may not be culturally competent mental health supports to access that diagnosis. Sometimes ARCH receives questions around the intersection between provincial social assistance and federal immigration systems. As you might know, a resident who sponsors a family member to come to Canada must first sign an undertaking to financially support that family member for a number of years, a set number of years. Questions arise, though, when that sponsored person receives OW or ODSP, Ontario Works or Ontario Disability Support Plan, during the years that they're meant to be sponsored. And the IRP, the Immigration and Refugee Protection Act, permits the government to take legal action against that sponsor to recover that ODSP and OW payment. And there's been some recent case law from the Supreme Court saying that the government has the discretion to defer but not forgive these debts held by sponsors whose sponsored family members have relied on ODSP, for example. But there are emergent questions about what these rules really mean to people with disabilities that haven't been tested by the courts. One of the emergent issues is the accessibility of long-term care for sponsored family members who may need to rely on ODSP or OW to cover long-term care fees. And the question is, what's the impact on the sponsor when the sponsored party accesses the ODSP that they're entitled to? The excessive demands provision of the Immigration and Refugee Protection Act is another example of the barriers that are faced by persons with disabilities who confront and are confronted by the immigration system. And in those cases, typically a person or a family, including a person with a disability, apply or intends to apply for permanent residency or for a visa. And the IRPA, the Act, permits visa officers to find that a person with a disability is inadmissible, medically inadmissible, if they believe that their disability will result in an excessive demand on the healthcare or social services systems. And so people with disabilities, again, find themselves excluded because of these rules, which unfortunately rely on stereotypes that people with disabilities don't have anything to offer or anything to contribute to society. So these are some examples of the ways that these questions come to ARCH. And so let's get started with our excellent panel. And we're first going to hear from Tom, who will speak to the experience of refugee claimants with mental health issues and the experience of newcomers involved in the criminal system as a result of their mental health issues. And then we'll next hear from Carol, who will offer some examples of the disability issues that arise in her work at the Refugee Law Office. Okay?
Good afternoon. How are you? Thank you for having me here this afternoon. My speech today focuses on the issue of healthcare coverage for refugee claimants who have mental health conditions. I also share with you 2 case examples I have come across during my frontline work in relation to immigration policy of deportation on people who may have committed crime due to mental illnesses. We all know most refugee claimants go through traumatic events in their life before reaching asylum in Canada. They need mental health care. I know it very well because I was a Vietnamese birth person myself and had post-traumatic stress disorder when I landed in Canada 30 years ago. Recently, our federal government cut healthcare coverage for refugee claimants unless it is proven their illnesses are critical. Nowadays, refugee claimants with mental conditions have been left without proper treatment because they cannot afford to pay for specialists in psychiatry. The consequences is they may develop psychosis. They may committed crime, which affect every one of us. Speaking about inclusion for racialized people and refugees with mental illness, we need to examine our government healthcare policy to ensure that accessibility and inclusion must be taken into consideration. In relation to mental illness and immigration law of deportation order apply to immigrants who may have committed crime because of mental illnesses, and also on refugee claimants who have diagnosed with mental illness. I would like to cite two case examples that I have followed up. The first case is a young Vietnamese immigrant who had been diagnosed with major depression disorder in association with psychosis feature. This young man's brother is also having bipolar disorder, and his mother had depression since his death. This 22-year-old man migrated to Canada at age 10 with his parents and 4 other siblings from a refugee camp in Hong Kong. During the course of settlement in Canada, this young man developed depression symptoms with feature of psychosis. He was convicted of drug trafficking and carrying weapons. He was deported to Vietnam. Regardless, his appeal for humanitarian and compassionate ground based on his mental health condition. And he already lost ties with Vietnam many years ago. His appeal was turned down. He was deported to Vietnam without proper support. He had no relative there. He left Vietnam when he was a child. He spent 5 years growing up in a refugee camp. He lost his root in Vietnam already. Since his deportation to Vietnam, he was sent to a mental health camp without decent treatment and support for people with mental illness. He hung himself to death after 3 months in a mental health camp in Vietnam. His mother in Canada was so devastated for the death of her son and has developed major depression disorder ever since. The second case is currently on the list of deportation order to Vietnam. The person is a refugee claimant. While waiting for the hearing with the Immigration Refugee Board, she had a car accident while on the way to work at a farm. She acquired brain injury and became disabled. Her physical condition escalated to a mental health condition. She has been diagnosed with major depression, organic disorder, and having psychotic symptoms. She failed to be recognized as a conventional refugee. She failed to be considered to stay in Canada based on humanitarian and compassionate ground. She is currently on the deportation order list and must report to the immigration authority weekly. In addition to the worst of her mental health condition, she has been traumatically living with fear for her life and fate once she is sent back to Vietnam. Canadian immigration law has failed to protect human rights when it comes to healthcare policy and deportation order, which are applying on refugee claimants with mental health issues and on new immigrants who may have committed crimes activity due to mental health illnesses. Canada immigration law failed to respect the Canadian Charter of Rights and Freedom by sending new immigrant and refugee claimants with mental illness back to the country, such as Vietnam, where human rights have been violated, where had no proper treatment available for people with mental illnesses. Those people are put into a system of indignity, disrespect, and inhuman conditions. They are locked up. They are denied a very basic right that people with mental illnesses in Canada enjoy. It is the right to decent medical treatment. I hope that Citizenship and Immigration Canada will respect the Canadian Charter of Rights and Freedoms and stop deporting people with mental illness to countries that do not provide treatment to these individuals. Lastly, by deporting people with mental illnesses without considering their mental health condition and available treatment is tantamount to sentencing the individual to a slow and painful death. Thank you very much for listening to my speech.
I too suffer from Diane's infliction, which is that I tend to speak very quickly. I'm going to try my best to slow down, to give my ASL interpreter beside me an opportunity. But again, feel free to nudge me, poke, whatever it takes. So, to start, thank you to Arch and to the Law Society for inviting me here this afternoon. Before I actually begin my talk, I want to just pick up on something that Tess said about the undertakings and the difficulties that they pose to our clients. And just to let you know that Minister Kenny, who I'm convinced never sleeps, he has most recently announced that he's going to be increasing the age, the duration of the undertaking from what is now 10 years to 20 years, which means that if you sponsor your parent or your grandparent and they need ODSP, the Ontario Disability Support Plan, for example, they will not be able to access it for 20 years. We're talking about your parents and your grandparents, so imagine. And if they do access it, then, as Tess referred to, the case of Mavi made it clear that the government cannot forgive that debt, but they can make accommodation for the repayment of that debt in very, very small payments. So that's something I put out there. It's not too late to do something about it, and that's why I want to put it out there. Most importantly is that it is still going to have to go through Parliament, and this is your opportunity to take a stand and write to your Member of Parliament and say that this is unfair. As part of the package, that it's also going to decrease the age of dependence. So currently, if you're under 22, you are considered a dependent of your parents. They want to decrease that to 18 years of age. And we know, especially in racialized communities, that children, especially, and nowadays even in non-racialized communities, children are staying home and living with their parents for much longer than ever before. And so the age of dependence is going to disproportionately, I think, affect racialized communities. And as I said, it's not too late to do something about it. So that's my little plug. Okay. Now, the focus of my remarks will be on the challenges that face racialized persons with disabilities in the immigration and refugee world. I begin by putting a caveat to that because I'm not going to be talking about all of immigration and refugee law, because that topic would keep us here for a few days rather than a few hours, and I'm going to talk about the area that my office, the Refugee Law Office, which is a staff office of legal aid, what we specialize in the most, and the experiences and the challenges that we face on a daily basis. So, for example, I will not be dealing with family class sponsorships. I'm not going to be dealing with the foreign worker program, which was in the news a lot recently, and I'm sure many of you read about that, or seasonal agricultural workers. And not to diminish the challenges or the discrimination and exploitation that those immigrants and workers, foreign workers face, but again, I'm going to limit my talk to the RLO's expertise. So the RLO, we, like many clinics, we're a mix of lawyers, community legal workers, and one of the things that I think makes us really special is that we have a social worker on staff. And for the topic that we are discussing today, the social worker makes certainly my life, much easier than before we had the social worker. In terms, our office has developed an expertise in 3 areas. In detention, so we assist detainees who are on an immigration hold, and they are detained for 2 reasons primarily. Either they have just arrived in the country and are making a refugee claim, and that's the second area of specialization, is the refugee claims. I'm not going to spend too much time today talking about the challenges in the refugee claim process, because I only have 20 minutes, I've been told. So, but I am around later. I'll be around for the cocktail, and if people have specific questions about that, I'm happy to address them. So, refugees, like all of us, they come in all forms and have a range of abilities. Sometimes their disability will be related to their reason for being a refugee and will be related to their persecution. Other times not. So a person who's hard of hearing, I've had interesting claims where deaf clients need, for example, I recently had a case where I needed to find a Finnish ASL person or SL person, and we couldn't find a Finnish SL person. The client was from the Horn of Africa, and it just so happened that she learned Finnish Sign Language because those were the missionaries, and that had come into the village, and that's what she learned. So it wasn't even it didn't have anything to do with her country of origin or the reason for her persecution or the reason why she fled. It was just an additional hurdle and communication challenge that we had to obviously accommodate. Am I talking too fast?
No, so far it's okay.
Okay, thanks. Okay, so sometimes, on the other hand, the disability is directly related to the reason for the persecution, and I'm thinking of a case where, again, person from the Horn of Africa, where people with serious mental health issues, illnesses, are chained to a tree. That's how they are treated. There's picking up on what Aisha was saying, that in certain cultures, I mean, even in Canada, mental health is stigmatized and there's so much discrimination. But in this particular country, the way they dealt with the mentally ill is simply to chain them up to a tree and let the birds go at them. That was the basis of their claim. And so you could see that it spans the whole range of reasons for persecution and disabilities. The third specialization that our office deals with on a regular basis is clients, and Tom spoke about this, clients who are detained who are facing removal from Canada. Many of these clients are long-term permanent residents of Canada who have been here since they were children and are now, usually as a result of their mental illness, have had an interaction with the criminal justice system, and as a result of that criminal conviction, face deportation or removal from Canada. Those are the clients that I want to talk about. And picking up on one of Tom's comments, where he said that he thinks that Canadian immigration policy has failed persons with mental illness in particular. I totally agree with that comment. So I think the thread that runs through the 3 areas of specialization that our office has developed is that the clients tend to be extremely vulnerable. They are, some people would call them high needs. They need a lot of attention and patience. And many lawyers are unwilling to take on these clients because of the legal aid tariff. And so our office tries to address this gap and ensure that persons in detention or vulnerable clients have access to counsel. We recognize that the immigration system and process take a huge emotional toll on people and often exacerbates the existing mental health issues, and this is exponentially greater for persons in detention. For persons in detention, the mental health issue doesn't go away. It often becomes worse. And it leads to the person's deterioration. Detention conditions aggravate the symptoms of the mental illness, making detention extremely difficult to cope with. And this can sometimes affect the person's ability to instruct counsel because they are so overwhelmed by the conditions of detention that what's driving some of the decision making is, I want to get out. I want to get out. I want to get out. And fair enough. Detention, I've been to the detention center a lot. But then you have to ask, okay, what else? Is that the only thing that's driving this decision? And so, for example, picking up on Diane's comments earlier, we have to consider the capacity issue, and sometimes it arises, I think that it arises in our office in any case, it has arisen the most when the person is detained. I don't think it's a coincidence given the conditions of detention. So we had a case of a person that was detained. He was a long-term permanent resident of Canada who, as a result of his mental illness, was convicted of a few different kinds of things. He was found not criminally responsible for two incidences, two charges, and then he also had some other criminal charges for which made him criminally inadmissible. Tess spoke about being medically inadmissible. We can also be criminally inadmissible. And because he was actually one of the lucky ones, because at the time he got a sentence of less than 2 years. And so he had a right to the Immigration Appeal Division. And on that note, I'm going to make another little plug. There is it's just past third reading in the Senate. There's a new bill, Bill C-43, that aims to change the rights of appeal for permanent residents and foreign residents to make it, to reduce people who have access to the Immigration Appeal Division from anyone. It currently is, if you've been convicted of 2 years less a day, you have a right of appeal. And the C-43 would decrease that to 6 months less a day. Yeah, I see some, gasps in the audience. That's right, 6 months less a day. And anybody who practices criminal law would realize how many people that is going to affect. And it doesn't matter if the person has been here since they were a child. I have clients who have been in Canada longer than I've been alive. So people who are here for 50, 60 years. We're dealing with somebody just this week who's facing deportation after 53 years in Canada. So, yeah. So, these immigration appeal divisions, they can lead to 3 results. They can be granted. The appeal is granted, which is quite rare, but sometimes happens. It happened most recently in a case where I had a gentleman who had suffered a severe stroke and was only able to communicate by nodding. And so we were able to accommodate him, and I had to remind the board members several times to only ask him yes or no questions because he couldn't testify any other way. And the board member agreed that the appeal should be granted given his condition, and that at this point it was highly unlikely that he posed a danger to the Canadian public, which is one of the things they're always trying to balance. So that's when they will grant the appeal. Exceptionally, exceptionally rare. I just gave you the example. Or they will dismiss the appeal outright, which sometimes happens. And the third category is where they will grant what's called a stay of removal, and they'll put the person on terms and conditions. And in my opinion, the conditions are often very coercive. And so for persons with mental health issues, some of the conditions will be that you must continue to take your medication. You must continue to be followed by a psychiatrist. You must consent to having an ACT team follow you for the next anywhere between 3 to 5 years. Sometimes if they reoffend, a minor reoffends during that period, that stay of removal could continue for another, we have a client now going on 12 years that they've had to comply with these conditions. For addicts, we see the condition that they must not take any alcohol or consume any alcohol or any drugs. And again, these are very coercive conditions that we would very rarely find in the criminal court context, where it's been recognized, the medical literature recognizes that the harm reduction model is much more effective than the abstinence cold turkey model. But back to my example, my client. So he had his stay canceled, not because he committed another crime, but because he had failed to give Canada Border Services Agency and the Immigration and Refugee Board a change of address. And so all of the clients that are put on these terms and conditions, that's one of the statutory conditions, is that you must provide CBSA or the IRB your change of address before you move. He forgot, right? Not shocking that he forgot. He suffers from schizophrenia. Changing his address was not the foremost thing on his mind. And so 3 years later, he found himself with his appeal being dismissed and with no status. Well, the next time he got in trouble with the law, oh my God. Okay, see, now she just showed me the 5-minute sign, which means I'm going to start talking faster. So he found himself, we didn't represent him at that time, but the next time he was in trouble, he found himself detained and at Metro West Detention Center. And at that point, we met him, and we laid out his options, and he advised us to pursue what they call a humanitarian and compassionate application. And we shorthand for that, H&C application. He gave us the $550 that it costs to pursue the application. We filled out all the papers. He was, as I said, he was detained at the time. He went back on his medication, and he was fully able to instruct us. It took a year for the application to be processed. During the course of that year, we saw him on a regular basis every 2-3 weeks. As I said, we have a social worker on staff who would go and check in, and he also was having detention reviews every 30 days. But given the stereotypes that are often attached to racialized persons in detention who have mental health issues, the whole thing about, well, he's going to be dangerous because he was found NCR twice, and therefore he's dangerous. And so much as we tried to get him released from detention, we were unable to. A year later, the H&C decision came back negative. And at that point, we again went and sought his instructions on what to do next. We laid out his options. He instructed us to seek judicial review to the federal court. So we filed the application for leave, And about 30 days later, CBSA, Canada Border Services Agency, went to see him, unbeknownst to us, and asked him about going back. At this point, he had stopped taking his meds about 4 weeks earlier and said, yeah, I'd like to go back. I want to go fishing with my father. And so, long and short of it, because she's just given me the 3-minute warning, long and short of it, I knew that his father had deceased years ago. And so I had concern about his capacity to instruct us to no longer fight his removal. And because at that point CBSA was ready to remove him, we had gone asking for instructions to bring an emergency stay motion to the federal court. He said, no, I want to go fishing with my father. Well, as I said, at that point, I was very concerned about his capacity to instruct me, and so I went to court and I asked for an interim stay. An interim stay to be able to go and get a psychiatric assessment. And the court granted it to us, and so the deportation order was stopped for the moment. A psychiatrist from CAMH went out and spoke to him for several hours and reported that he did not have the capacity to instruct counsel at that time. Interestingly, CBSA retained a family doctor to go out there, and the family doctor came back with a report saying, sure, he's got capacity to instruct counsel. So the next time we were back in court on the motion, it was a little battle of experts, and the court went with the psychiatric expert, not the family doctor. And also, given the circumstances of the case, that this was a long-term permanent resident, as I said, CBSA could certainly hold on a few months until the judicial review process went through before removing him. And so the case highlights some of the difficulties that arise, oh my God, 1 minute, that arise when dealing with this client base, particularly with those in detention, whose instructions are sometimes motivated, as I said, by a short-term desire to get out of detention, as opposed to what will happen to them. That's not to say that every time a client gives you instructions that you disagree with, or that you believe aren't in their best interests, that you should follow them. Absolutely not. We sometimes get clients who come to our office and say, I want to withdraw my refugee claim. And even though I think that that's dangerous for them, if they're in my office saying, my mother is dying and I will never forgive myself if I don't see her before she dies, what can you do? If she's capable, those are the instructions. You follow them. They withdraw their claims and they go off, and you hope that they'll find safety. It's important that counsel, as I said, respects the client's instructions, even in those circumstances. I wanted to actually then, I'd listed out a whole bunch of accommodations, and so I'm going to just take 30 seconds. Okay. Number one would be to create a safe space. I think that's really important. I think that's one of the things that we do well. Number two is building trust with clients takes time. This is particularly difficult given the latest changes to the Immigration and Refugee Act, where clients now have their hearings in either 30 days or 60 days, and you only have 15 days to do basically it's the basis of claim. It's like a statement of claim. And so you have to build up a rapport with somebody within those 15 days. It's almost impossible. But we're trying. Not to say that we're doing it that well, because I think 15 days is still so limiting, but we are trying. And there are ways of doing that. And one of the ways of doing that, picking up again on Diane's comments about when you're asking about, does the person need accommodation? As she said, I like those words, I'm going to keep them. Don't pretty it up. Be direct, be frank, ask. And it's the same thing with the clients that we sometimes deal with who are suicidal. You don't pretty it up and say, oh, are you thinking of hurting yourself? Or are you thinking of harming yourself? No, you be direct. Are you thinking of committing suicide? Have you thought about it in the past? Do you have a plan? What does that plan involve with? Do you have the tools to execute that plan? Those are the questions that you have to ask. You can't pretty it up. And that's how you actually build trust. Because if the person knows that you're going to be direct with them, I have found that that's a really good way of building trust. So ask if they need accommodation. Ask them alone, again, as Diane said, if they want or need a support person. Build up those supports. Recognize the issues of gender, socioeconomic status, sexual orientation, sexual identity could further compound the situation. And on that note, it's actually a good news, I'm going to end with like one little good news, is that the federal court is starting to recognize the intersectionality of these things. There's been a couple of decisions out of the federal court where they have quashed decisions where the officers or the tribunal members have said, okay, I'm going to look at your disability, and I find that you don't face persecution or hardship because of your disability. Then I'm going to look at your race, and I find that you don't face persecution or hardship because of your race. And then I'm going to look at your sexual orientation, and I'm going to do the same thing. And the court says, no, 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 no. You can't separate it out that way. That's not how people live. That's not who we are. And so you have to look at the intersectionality. And so that is one of the few good news stories that I have to say. Find good referrals. So the organization that Tom works with, find other good referrals, Arch Disability Center. As Tom was saying, there have been significant cuts to the interim federal health program, which certainly is impeding our ability to obtain reports, psychiatric reports. It's impeding our ability for the clients to get counseling and medical care, mental health care. And but there are some community safe spaces that are still treating clients. There's the community health centers that are still treating clients or non-status people. And so you have to be creative, as Diane said, and find those supports that are out in the community. And I think those are the highlights because I'm out of time. Thank you.
We have some time for questions, maybe two or three questions. So because time is limited, we're just going to ask people to make sure that their questions are brief so that we can get through as many questions as possible. And also when you're asking your questions, if you can make sure to avoid using specific names or names of agencies. So if anyone has any questions, now's the time. Oh, hi, sorry.
First, I'm going to make a plug for the Day of Action, Monday, June 17. Oxfam is calling on people to assemble at Queen's Park at 11:30 to 1:30 about denial of health care for refugees. So if people can come out for that, that'd be great. On the issue of having support people in on these meetings, is there a problem then with solicitor-client privilege?
First, in our office, first thing that we do is we ask the support person to wait outside, and we have a conversation with the client. And then if the client says yes, we get the support person to sign a confidentiality agreement. And so we also then get them to sign some consent so that we can speak with immigration and with the board. And then what I try and do is, I think that the support people, in my experience, have been invaluable in maintaining that connection because so often immigration processes take so long. So the client might maintain a very good connection with me at the beginning, but then when the file goes into the black hole, otherwise known as, CIC, it could take 2, 3. I've got a client now, suffers from serious mental health issues, and that his application has been outstanding for about 6 years. And it's just exacerbating his mental health because he's like, I can't believe it's taking so long, right? Why is it taking so long? And it's feeding his paranoia about why it's taking so long. So in those cases, having a support person has been invaluable because sometimes, my clients forget to even tell me about their change of address, let alone immigration or CBSA their change of address. And then it's through the support person that I can find them again. I have other clients, on the other hand, who their case was closed years ago. We were successful, and they just dropped by the office to tell me that, he got new shoes, or he got a new apartment, or just, one of them dropped by recently to say that he had been in CAMH for 5 weeks and now he got out, and he just wanted to let me know that. So we get both extremes, right? People who, even at the very end, come to see us and maintain contact with us, and then people who don't. And when you want to try and find them, those community support people are invaluable.
Hi, I have a question, and maybe you may or may not be able to satisfy it, but there is a historical and long attitudinal problem for persons with disabilities. Attitude has been identified as the main barrier, even in the accessibility legislation, the AODA. But specifically, there's even a bigger attitude stigma about mental health issues. People don't talk about it, they don't mention it by name. When they say a person who has a disability such as blindness or this and that, but they don't talk about it openly like you guys have done, so thank you very much. But even in the latest review for ODSP and OW, the recommendation for how recipients of ODSP with mental health issue can improve their lives, I would think if you're ill, it should be something related to health promotion, right? Well, no, they recommend that they should go to work. When actually, the reason why they are not working and receiving ODSP is because of the mental health issue. This is the mainstream way of thinking about mental health. They have this stigma that you don't see it, then you don't have it. So is there anything that is being done through, I don't know, a training, some sort of approach, how to address this? Because the AODA, the first standard addresses customer service. You have to provide accessible customer service, so they allow you to bring a dog, they allow you to have a ramp. But what about accessible service for persons with mental health issues?
I'm going to defer to Tess on this one because I'm not an ODSP expert. My expertise is refugee law and immigration law, and very narrow at that. So, I don't know, Tess?
I was actually going to defer to Tom.
Well,
I was thinking about Hung Fook's work.
Well, it's really hard to identify that you are having mental illness or not, because the stigmatization and people tend to deny it. And also, if I'm talking about the program we serve at Hong Fook Mental Health Association, that in order to qualify for case management services in the community, you have to meet the 3D model set up by the Ministry of Health and Long-Term Care. That means disability, diagnosis, and the duration of the mental illnesses. So then, talking about diagnosis, who can make a diagnosis? You have to go to the psychiatrist for the assessment and get a formal diagnosis in order to recognize it. So then, so go through whatever sort of benefit that you want to receive, and then you need to get a formal diagnosis, and then the person have to accept that I'm having a mental illness and go through the system in order to be recognized and get it through. And of course, we have a lot of people, they just fall to the crack because they, with stigmatization because of their condition, they cannot get through that. So we still have that. And as again, that it's hard to recognize. Yeah.
Thank you. We have time for one more question over here. Thank you.
I just wanted to go back to the question about solicitor-client privilege, because I think Carol, what you're describing is sometimes we need the support person so bad, we'll just have to do with possibility of losing solicitor-client privilege. But the reality is that a confidentiality agreement does not protect the support person from being called as a witness to testify as to what you and the client discussed. And so it's really important to make sure that when you are bringing the support person in, that you explain the potential loss of solicitor-client privilege to them, and they understand what the consequence of that is. And then another alternative, where it's possible, is for the lawyer to retain the person who is acting as the support person, and maybe that might fall under the litigation privilege, and that might be one way around it. And we don't have cases yet where judges have really decided whether litigation privilege is breached, should be extended to support persons, and if anybody gets those, fight hard.
I'm not sure that there was a question in there, but it did.
Response.
Yeah, in response. But I was just going to jump in, if that's okay, because what you said reminded me of the supported decision-making models that Diane started to talk about. So in those cases, the decisions are being made by a group of people, and so in those cases, the retainer is actually with the circle of people around the person with a disability. So in those cases, is this just a different way of positioning yourself, arranging the relationship between solicitor and client? Does anyone else have anything to say about that? Any comments?
No, we also get the interpreters to sign the same confidentiality
right.
declaration, and I guess maybe in family law or civil law that would come up. It hasn't come up in refugee and immigration law because, I mean, it's us against the minister, and
Well, thank you so much. So that's the end of this panel. I did want to just say that I hoped it was clear from all of this on this panel that there's a lot of issues that arise for racialized people with disabilities who are before the immigration system, and there's a tremendous need for legal services in this area. Unfortunately, changes to Ontario's legal aid system has made it difficult for people with disabilities to get assistance before the immigration system. So ARCH sometimes receives calls from people with questions about their immigration status, but for whom we are unable to serve them and for whom we lack adequate referrals to offer them. So we're hoping to develop a broad list of lawyers, including immigration lawyers and paralegals, to receive these referrals, including outside of the GTA. And additionally, ARCH is interested in increasing the ability of the private bar to provide these kinds of services to the disability community. And to make this happen, ARCH offers a case consultation service. So if you're a lawyer or a paralegal with questions about how to work with a client with a disability, don't hesitate to give us a call. Thank you. I think we are going ahead with the next panel, or should we we'll take a short break before the next panel starts in about 5 minutes, 10 minutes. Okay. Thank you.
Did I volunteer? I'm just going to adjust my mic. Good afternoon, everybody. We're going to get started again, so if everyone can kindly take your seats, that would be great. So my name is Carrie Joffe, and I'm another one of the staff lawyers at ARCH. And I'm very happy to be here this afternoon to moderate the panel on family law and child protection issues. This afternoon's panel will look at issues related to autonomy and inclusion for racialized people with disabilities in the area of family law and child protection. Generally, family law is not an area in which ARCH practices. But like the other panels this afternoon, we are very interested in creating and enhancing our list of private bar referrals, because we do receive quite a lot of calls and requests for assistance from people with disabilities who have family law and child protection matters that they need assistance with. So I wanted to just give you a little bit of a flavor of the kinds of issues that we hear about from people with disabilities in this area of law. And I'm going to touch on sort of 3 kinds of issues or topics that we hear about through our summary legal advice and referral service. So those are people who call us and make requests for assistance. So we hear from parents with disabilities whose children are being apprehended or who are in danger of being apprehended by the child welfare system. And in many of these cases, the parents will state to us that they are willing and able to raise their children, but the child welfare officials may disagree. Attitudinal barriers exist, and that's something that we've discussed with the other panels as well this afternoon. And assumptions are made that people with disabilities will not be able to fulfill their parenting role because their disability prevents them from doing so, or because they themselves require disability services and supports. We've also heard from parents with disabilities who have requested disability accommodations, such as the provision of ASL interpreters or attendant care services, but child welfare agencies are sometimes resistant to providing or paying for these kinds of accommodations, and that can have a really damaging effect on the ability of the parent with a disability to demonstrate that they have parenting skills or to communicate effectively with child welfare and to be able to understand what they need to do in order to comply with court orders or to demonstrate their ability to parent. And a third issue that comes to us fairly frequently is the question of adults with disabilities who are subject to or may be subject to custody orders. So these are situations where an adult with a disability may live at home and be dependent financially on their parents or on one parent or other family members, and may also be dependent on them for assistance with activities of daily living or other kinds of physical and mental health care. And so in these situations when parents split up, the adult with a disability may find that they are in the middle of a custody and access dispute where both parents are wanting the child or the adult to live with them or to visit them a certain amount of time. And the person with the disability may have other ideas, other wishes and desires about how they want to structure the custody and access situation. So in some of these cases, the courts will consider the wishes of the adult with a disability, but we've also encountered situations where, again, attitudinal barriers exist and assumptions are made that the person with a disability may not be mentally capable of expressing their wishes around custody and access. So these are obviously very complex legal issues, and they are made much more complex when people with disabilities face barriers related to race, culture, and ethnicity in these contexts. We need creative lawyers who are knowledgeable in family law, human rights law, disability law, and international law as well to help us and to help people with disabilities to try to deal with some of these situations. And I mentioned international law because the UN Convention on the Rights of Persons with Disabilities may also, and we at Arch hope that increasingly it will become a useful advocacy tool in family law and child protection cases. It includes articles that relate to the rights of children with disabilities, women with disabilities, and the provision of respect for families who have members who are people with disabilities. So I look forward to hearing this afternoon from our two panelists on these and other issues that racialized people with disabilities face in the areas of family law and child protection. I'm going to introduce our panelists one at a time, so right before they speak. And our first panelist is Melanie Moore. Melanie is a social worker who is currently a community development worker with the Centre for Independent Living in Toronto. As the coordinator of SPIN, Melanie provides education and awareness training to service providers and practitioners about parents and prospective parents with disabilities. And Melanie's full bio is in the materials this afternoon, so please have a look. Welcome, Melanie.
Good afternoon, everyone. Just a couple of things before I start. I typically use a lot of humor when I present, and I find it humorous, but maybe not everybody will. So if I chuckle, it's okay, and if you don't find it humorous, it's okay too. So my name is Melanie Moore, and I just want to kind of set the stage a little bit before I go into what I'm going to speak about. So I am a parent. I am blind, visually impaired, or visually impaired, whichever your preference is. I'm an Aboriginal person, okay? And I do work at the Centre for Independent Living in Toronto. So this presentation is more from my own personal experience. I'm a parent, as I said, of 3 children, and the ages are ranging from 6 to 30. So all these things that I just mentioned, all this information impacts my knowledge about the effects of intersectionality. When you are working with consumers or clients, it's important to think about all facets of their lives, and I am here to explain why that is important from my personal story and by using some case examples. My parents are both Aboriginal. My mom was from the Mohawk tribe, Six Nations Reserve, for those that know that area. And my father was from the Ojibwe tribe, which is First Nations. No wonder they got divorced, because these 2 tribes do not get along well. And all this is really important. My grandparents, so my mother's parents, have land on the Six Nations Reserve. But as a child growing up, we spent a lot of time visiting the reserve, so on the farm. I loved going to the farm, picking vegetables with my grandmother and swinging on the wooden swing that my grandfather put up. I remember swinging on the swing, feeling the breeze on my face. It was quite a peaceful time. My mom did not raise us with the traditions because her customs were shamed out of her by the reserve schools that she attended. Because of this, I didn't know my culture or the traditions that I needed to learn. Although it's something I am trying to currently work on. During my studies at Carleton University, I began to learn about the policies and practices of Native peoples, including discrimination we faced. I couldn't believe that as soon as a Native woman got married, they were no longer part of their tribe and essentially were not seen as women. I found that so disgusting. I'm truly, truly pleased that that's been changed. Thank goodness that's changed. During my studies at Carleton, I attended a smudging ceremony for the first time in my life. The professor that I had at the time was an Aboriginal professor, And he had approval to teach us about the white paper, for example, using a smudging ceremony, which was incredible. It wasn't nearly as dry as I thought it would be. And I enjoyed learning about policies through that method of learning, which I'd never learned before. And the way it worked was he would do the smudging ceremony, and then he would hold a feather or a rock or a stone, which I have up here with me, and would talk about the white paper and what he wanted us to learn. And then he would pass the stone or feather around, and we would each have a turn. And I said to him, I said, well, holy cow, I am not going to remember everything that you're saying. And he says, it's okay. You will remember what you need to remember. I also learned about what the talking circles were, which I just spoke about, and I'd never learned that before. I'd never learned about it before. I began, during all his lectures throughout the year, to understand why I believed in the things I actually believed in. For example, learning through stories. I was never one to read a book and then just cite it back to people. I learned far better through stories, and I never understood why that was important. And he explained to me that that's your heritage. That's why you learn that way. I learned that my intuition, that was another skill that many Aboriginal people have. And also why trust and respect were so important. I used to think, oh, well, it's just me kind of going over the top, but it's not. It's because it's something that's fundamental to the core beliefs and traditions of Aboriginal people. However, when I moved back to Southern Ontario and attempted to attend women's ceremonies, I hit several brick walls or attitudinal barriers within my own community. This devastated me. I couldn't believe it. It's a learning curve. That's okay. My experience has been that as a blind woman, the Aboriginal community does not know how to deal with me, and they are afraid of my disability. Not all, but some. The Friendship Centers are making programs more accessible for people with disabilities. So they're beginning, and I'm really glad about that. But it's important to know where they were and now that there's progression. Now, some of us here know that education and awareness will assist this process, but I am here to tell you that it's very hurtful when you're not accepted in your own community, in the community or out of the community. In my opinion, attitudinal barriers are one of the worst barriers to cope with emotionally. As I mentioned, I have 3 boys, so they don't know the traditions that we need to have or the heritage. They only know a little bit that I've been able to teach them. I know that eventually they'll learn more, hopefully. But because I don't know, then they don't know. And again, because my parents didn't know, I didn't learn either. So it becomes generational, after generation, not knowing the heritage, which is a shame. But at least we're beginning. Not knowing my own traditions has affected us for several generations, like I just mentioned. Like many parents, they also were fearful. My parents were also fearful of my blindness, and they didn't know how to cope with it. And that came from how Aboriginal communities and tribes believed that blindness was a curse. But it also depends on who you speak to. So again, as many panelists have spoke, it's about asking those questions so that you understand where they're coming from with their heritage. In Toronto, Anishinaabe is providing services for a gentleman and other people that are blind, so they're beginning. Being blind and Aboriginal and a woman is like having several strikes against you, because reserves aren't accessible And many elders can be discriminatory, not intentionally, but they are discriminatory. Our culture is supported, is supposed to be supported, supposed to be helpful for all of us in difficult times, and we need to work on that. Now I'd like to draw your attention and share some stories while maintaining confidentiality. So this is more of the work that I've done with the Strength-Based Parenting Initiative and some of the family examples. I have several family members. Holy moly. Okay, well, when I did this, it was quicker. This is really hard to do in Braille. Many Aboriginal people face stereotypes of being drunken. That's not the way they are. Many of us, with education and awareness, learn how to carry on with your lives and be helpful. But I just want to draw your attention to, there's been many parents with disabilities that are Aboriginal that have had their children apprehended, and that's a shame, and that needs to stop. And I know that that's changing, but please remember that when you are apprehending the children, we all know that safety is at the end of it, that we all want that for our children, but at least put them in homes where there's an Aboriginal heritage, as well as you're taking into consideration all the other facets of their life, like their age. And if at all possible, leave them with a family member. So it could be an aunt or an uncle or a grandparent. It doesn't have to be in the home if it's not a safe home. There's many options. Thank you.
Thank you very much, Melanie, and sorry to cut you short. Our second panelist is Victoria Starr. Victoria is an experienced lawyer, mediator, and arbitrator who has practiced exclusively in the area of family and child protection law. Victoria chairs the Family Lawyers Association of Ontario and is the vice chair of the Ontario Bar Association's Family Law section. And Victoria's full bio is in the materials for this afternoon, so please have a look. Victoria is going to do her presentation here, and welcome, Victoria.
Great. Thanks. No. Well, you can just tap me. Okay, so just 5 minutes. Just go like that. Yeah. Okay. So, good afternoon, or almost evening now. I structured my comments today around the work that I do in terms, and I want to focus on advocacy and the lawyer's role, the client's role for those of you who are people with disabilities in the audience, and the service provider's role, and sort of the intersection of all of these. But I want to start just by highlighting for you some of the things that, or some of the issues and idiosyncrasies about family law and people with disabilities and how this intersects. So one of the things you might not know is there's a difference between, and when it comes to child support, is there's a difference in the language in the Family Law Act, which applies to unmarried couples, and the language that applies in the Divorce Act, which applies to the children of married couples. Where it comes to children who are over the age of 18. So if you're under the Divorce Act and your parents are married and one of the parents is looking for child support, then the test, you can get child support if you're enrolled in a full-time program of education or school, but you can also get be over 18 and not be in school, be unable to withdraw from as long as you can show you're unable to withdraw from parental control, due to, say, for example, a disability, and unable to provide yourself with the necessities of life. That language is not in the Family Law Act. In the Family Law Act, you have to be enrolled in a full-time program of education and a program of study. So you can see how that could be quite problematic for children with disabilities who are unable to carry a full caseload. And what's really amazing is when you look at the cases being decided, and we have some recent cases being decided under the Family Law Act, you see judges getting around the whole problem by stretching the language of what's a full-time program of study. Right? So you see less hours. In fact, recently we had a case decided from Justice Curtis at the Ontario Court of Justice where she talked about what would count as full-time for this particular child, right, given this particular child's abilities. So that's one of the differences, one of the idiosyncrasies that I'm not sure everybody is aware of, even amongst the lawyers who do family law. Another area when it comes to getting, so the first one I want to touch on is really child support. That's what I'm talking about right now, is the children who are under the age of 18. The place where we see the most litigation or discussion or negotiation here on the child support front is the Section 7 expenses. And that is where there are costs associated with occupational therapists, speech therapists, interpreters, whatever you need. These can be claimed as a Section 7 expense. And for those expenses that might relate, maybe there are special dietary restrictions that may not fall directly under the Section 7 category. The other part, especially if you're a family lawyer, to remember is the child support guidelines, which are really a table that say if you earn this much and you have one child, here's the minimum you're supposed to pay. We need to remember that it's a floor. So where appropriate, a court can order an amount that is higher than the guideline child support table amount. And that's one way to try and get more child support for children. In addition, if they're not classified as a Section 7 expense. So when it comes to seeking child support for children who have disabilities, budgets become really, really important. You have to do financial statements and pay attention to those budgets. Make sure you get documentary evidence of the expenses. What are they? Are they medical? Are they necessary? Are they reasonable? You're going to have to show all that and also link it to the disability itself. Then we have, as I said, the children who are over 18. I've kind of touched on them in the sense that the difference between the Divorce Act and the Family Law Act. But in the case of children who are over the age of 18, the cases are all over the place because some children are receiving ODSP and some children are living in independent living centers, or they're not children, they're adult children, living in independent living centers. And so where this becomes difficult when you're looking for child support, so a child reaches the age of 18, is on ODSP and possibly living in an independent learning center, can they still get can you still get child support for that child? You can, but it's not that easy to do. You're going to have to lead evidence, and so for those parents in the room of children who are adult children, you have to lead evidence of the nature and extent of the disability, the cost, the services, and another point, part of that whole case of trying to get child support for these adult children is showing that whatever financial resources they have is not sufficient to provide or is inadequate to provide full necessities of life. And the cases are all over the map. So you have some cases where they say, yes, children over the age of majority who are living independent can get it, even though they're getting ODSP, and yet you have other cases where the adult child cannot get it, and it tends to turn around whether the ODSP is sufficient to meet the basic necessities of life, or whether the person can work, and et cetera. The other part that some lawyers and service providers and clients may not be aware of is we have software, the specialized software that we use in family law that does calculations for us. And it is important to input the ODSP portion. So if a parent is receiving ODSP, there's a portion that goes to, that's related to the child. It is important to input that in there. It may affect spousal support, which brings me to spousal support, another area where we see the intersection between disability and support. And here, if the spouse is disabled, the test is going to be pretty similar to what you saw in the child support, except for the education part. But it becomes really important to put evidence forward about the nature and extent of the disability. It becomes really important to let your lawyer know what services are out there and how they can or cannot help you become independent and self-sufficient. Self-sufficient, just like with the adult children over 18, really important. To what extent can you provide for yourself? Other parts of spousal support that are important for family law cases, for spouses seeking spousal support, is that, you know, when you get a divorce, most extended health care plans terminate coverage for the spouse. And so for a spouse who requires or is relying upon a lot of the extended health care plan benefits, the loss of that can be quite significant. And so we need to build into our spousal support amounts in situations like that, additional amounts to cover those expenses. Again, explicit detail is going to become pretty important. I think the place where we you know, the other part of what I do besides the domestic side of family law is child protection law. And that's an area where we see we really see the attitudinal barriers that have been talked about today, and what I would call fear, ignorance, lack of knowledge, all of that come into play, and probably where we see the greatest hurdles and the greatest barriers. So first of all, some areas where this comes up, you know, if you're on ODSP, you already have, you know, somebody was talking about privilege. There's already attitudinal barriers about people who are on social assistance. So that's a hurdle that somebody's going to have to face. It's kind of like a double whammy. Other things, flat affect. Not at all uncommon if you've worked with people with intellectual or mental health disabilities. You know, certain medication can really affect the affect, the way in the, you know, inflection and facial expressions and the way that they move. It doesn't mean they can't parent, right? It doesn't mean they can't parent. But people often think that this means that there's something wrong with them, that it means that they can't parent, even though that's not the case. We face a lot of lack of information in this area. Just like, you know, I guess it's across the board, but abled, or, well, I wouldn't call them abled, but, you know, the people who don't have disabilities, their experience and exposure to people with disabilities is quite limited, and they're afraid to ask questions, and you've heard that today. They're afraid to ask questions, and they're afraid because they don't know how to ask the questions, and also they're afraid because they don't know the extent of the accommodation that's going to be required of them, and pretty much kind of keep their distance. And so we have sort of a culture of unfamiliarity when it comes to people with disabilities. As I said, there are also the attitudinal and the fear stuff. So, it's really important to make sure that we overcome that by educating the people that are making decisions about children and the parents, and whether the parent is capable of continuing to parent her children. Another part, you know, sort of issue that comes up in child protection are parenting capacity assessments. So it's not at all uncommon when this happens, especially with mental health, people who face mental health issues. Nobody knows what to do, and so somebody will suggest, let's get a parenting capacity assessment done of this parent. And that's kind of, you know, it's usually an expert picked by the Children's Aid Society or the Child Welfare Authority, and we don't know whether that person's going to have familiarity with the particular disability. So it becomes really important, if you're advocating, if you're a service provider, speak to the lawyer. If you're a lawyer, if you're a client, think about whether, you know, think about questions like, should I really agree to a parenting capacity assessment? Because the problem with parenting capacity assessments is they're like the voice of God in the courtroom, okay? The judge is probably going to do what the assessor says to do. So you really have to think before you do this. And at this, think about the timing of this too. Person's been a parent for a long time. Suddenly this becomes an issue. Their child's in foster care. They're facing all these barriers. They have their own challenges arising out of their disability. They may have cultural barriers, language barriers, all kinds of things. And suddenly we're going to put them in a room with somebody who's probably educated in the dominant culture, probably shares a lot of the privileged assumptions and lack of knowledge about a particular disability, and ask them to tell us whether this parent can parent, has the capacity. So as lawyers or service providers, you really need to put some thought into who is going to do if you're going to agree to it, then who, and you say yes, then who's going to do this assessment? And you really need to intervene with the assessor to make sure that the assessor understands the nature and extent of the disability, and that you make sure that you put, information before the assessor about services out there, because it may be that the parenting capacity assessor doesn't go the extra mile to find out, the issue isn't, it's, can they learn, and then if they can learn how to acquire this new skill, can they do it without or with supports? And if they can do it with support only, then we need to know what supports will help them be able to meet whatever the expectations are. So it's really important to make sure that information gets in front of the assessor, so that the assessor report can comment on that, right? And so it becomes about educating the assessor. Same thing happens in custody and access disputes. We have Section 30 assessments. So they are basically evaluations as to which parent is best able to meet the needs of the child and the child's needs, and which parent can do it. And here we also see gender issues come into play in terms of how how women in particular may respond. And so if you put in gender issues, gender power issues, you put in some cultural issues. She may not have a job, she may not speak the language, she may not have been here very long, and is quite powerless and hopeless, and suddenly she has to face, she's been assaulted and she has to try to get a restraining order, and she's thrown into this court system, and now we're going to ask for basically a parenting assessment. Again, take control of the assessment process, and make sure, if you're a client, that you make sure your lawyer takes control of the assessment process. And if you're a service provider, make sure the lawyer has the information they need for that. Also, in child protection cases, the Child Welfare Agency will always provide a plan of care if the case is in court. And it's really important to look in that plan of care. There's a section that says, here is what we expect the parent to do. It's really important to look at those expectations, figure out if they're realistic, figure out if they are realistic, with what supports, and then go out and get them. And it's good to use these as checklists, so that every time you come back to court, you can say to a judge, well, I've done this and this on the list, and I can do this with this support. All right. Custody and access, so really we see disability intersect with custody and access, not so much on the custody part, unless there are mental health issues, but on the physical disability side of things, people just can't imagine how are there, safety concerns become an issue. If you're blind or you have visual disability, how are you going to adequately or properly supervise your children now that your spouse is not there? Or if you're on, will you be able to provide for your child's needs given your your economic background? So it's again important to make sure that these barriers are overcome. When you're working with the service providers, I've kind of touched on this in terms of making sure, so there's sort of working with service providers to get information and educate yourself. Find out what's out there, what resources are out there. Contact ARCH, contact various agencies to find out what's there, and then get those services in place. There's also working with the service providers to get them to, so if it's a family service worker or a child service worker with Children's Aid, make sure they are educated, because a child protection worker who doesn't believe your client can do it isn't going to be a good thing. Advocating for different workers if the worker is not culturally or sensitive to people with disabilities. There's also evidence and how you need to get the evidence before the court. Marshal your evidence in a clear and cohesive manner. If you're a lawyer out there and you're not certain your client can really do this, it's going to be really hard to be effective. So go and get the information that will help convince you so that you can convince the judge. Make sure you think about things like critique assessments. Make sure you cross-examine. One of the things that happens a lot is the opposing party, be it in a custody and access case or the child welfare agency, often will excerpt pieces from medical reports that are, when taken out of context, look really bad. And you might want to contact those people and say, hey, you know, is this what you meant? This is what the agency or the husband is saying about my client's ability based on this paragraph. Is this what you meant? And often that's not at all what they meant. Enlist those experts, those medical professionals. Don't bail on these clients. You know, working with people who have intellectual or developmental disabilities can be quite difficult and challenging. Throw in a little bit of culture here where you've got issues with respect to proximity. So in some cultures, it's natural to stand closer, to use more hand gestures, more touching, time issues, right? There are cultures where they're sort of what we call past-oriented, so they really think about, if you're late, it doesn't really matter, it's in the past, so they're late for appointments. These kind of things is if you've got this disability and then on top of that there are culture barriers that need to be cleared up or thought about. Culture intersects all over the place in family law, and it's sometimes hard to distinguish between what's related to the disability and what's related to the culture. But the focus here needs to be on, can the person do what they need to do to be a good enough parent? That's the focus in child protection. So lastly, the last thing that I wanted to just tell you is awareness and communication are key. For those of you who are lawyers or service providers, when you're meeting with clients with disabilities and something seems off, or you start judging them, or you start thinking, you know, they're kind of standing a little too close to me, there's something wrong. These are red flags. To me, red flags mean ask questions. That's the time to ask questions. That's the time to say, I don't really understand. Or if the client's saying to you, I don't really understand, you don't understand what I'm talking about or what I need, ask them, what do you need? Clients are the best source. The people with the disability are the best source of information. Most of us are already, if we've had our disability for a while, we are very well connected somewhere in the community. And then the last thing, so there's sort of awareness, communication, and the last thing I want to mention is accommodation. Fight for accommodation for your clients. And don't be afraid if you are a person with a disability. There's assistance set up now in court that will provide, if the lawyer calls in advance or you call in advance, that can arrange for accommodations to be made. Don't be afraid to ask for accommodation. I have been in court, in a court in the GTA area where I wanted to sit to make my submissions. Judge wouldn't let me, kept saying, stand at the podium, stand at the podium. Then finally I said, I can't see my notes, I'll sit down, and then repeatedly interrupted me throughout the day to say, wouldn't you rather stand at the podium, Ms. Starr? And at one point in the morning I turned to him and I said, I have a visual disability and I am asking you to accommodate. And that's it, and that's the end. Don't be afraid. I had to do it today. A Children's Aid Society lawyer told me that they would serve me maybe on Tuesday morning at court, and I said, I can't read the material if you give it to me Tuesday morning. I need the material by Monday night, and I need you to accommodate. Those are magic words for those people who have a duty, so use them. And also, finally, last comment, many people with disabilities and many people from different cultural backgrounds, because of the mix, especially now in culture, we are not visible, right? So we are not readily identifiable as people with disabilities. They're hidden, or our culture is hidden. So again, when something seems off, that's the time to ask questions. You're not always going to know, and they're not always going to tell. And, people like me, for example, who get very shy. I get very worried about whether I'm going to be judged by my disability. And so I don't often talk about it. I'm becoming more comfortable with it, but people will forget. And then it's kind of like, I've told you 10 times, I don't want to tell you again. So try to keep it in mind and think about don't forget the environment for your client when you're accommodating. Thank you.
Thank you very much to both of our panelists. We do have time for 2 or 3 questions. So again, I would just ask everybody to please keep them short and sweet and to the point so that we can get as many questions in as possible. And please don't identify individuals or particular agencies or organizations.
Ms. Starr, you mentioned that, yes, you're shy, but you also mentioned that when you brought up the issue of accommodation, it was respected. How come you didn't go right to that rather than suffer your shyness during the day? I hope you don't mind me asking.
No,
such a personal- Since I
I
have a hearing issue, I often come up with this idea, this problem of when do I raise it or do I not raise it and therefore suffer for it?
You can ask me anything, almost anything. But, you know, it's been a learning curve for me. So, you know, Melanie and I were talking about this, and Melanie has been blind since birth, and I didn't get this disability. I have macular degeneration. So I have a blind spot right in the middle of each eye, and I didn't get it till I was 22, and every year it gets worse and worse. So when I was 22, I could have stood at the podium. I could have stood at the podium until 5 years ago. I could have read a novel 5 years ago as long as I held it this close to my face. I no longer can, and you can see my notes are pretty big in order for me to just glance at them. So it's been I've had to grow into my disability and learn. And, you know, I think part of becoming, you know, a well-respected advocate in the community has helped me. I'm not so afraid that people will judge me because I have other things, you know, I'm just being honest, but I feel like I have other things to compensate for that judging. And I shouldn't have to even do that, but that's the way it is. So I'm really careful in social settings now. I will tell people right off the bat I have a visual disability, because that's where I find the biggest challenge is, you know, we don't realize how we make friends by eye contact and by passing people in the hall. And for me, it's the toughest thing, and people will think I'm rude or stuck up. And I have started, as a result of something that happened 2 weeks ago when I gave a speech on something else, the panel forgot that I had a visual disability, and they decided to do a back and forth PowerPoint. They all had a monitor on the floor, but I didn't. And I could, and it wasn't 1, 2, 3, 4, it was random. And it really threw me off, but everybody knew I had a visual disability. So I decided that from now on, I'm going to carry my cane, because it's an ID cane, so that I can, because, you know, people will come up to me and they'll say, how are you? You know, I've obviously had a very in-depth conversation, but I can't recognize their face because I can't see it. I have no idea who I'm talking to. So I've decided, and that's just recently happened. So it's really about growing into your disability as well and getting more of a comfort level. Most of the time, I always stand up. So when I'm in court, the first thing I do is say, Your Honor, I have a visual disability. I'd like to sit so I can see my notes. And I tell the judge, I can't see your face, which is often a blessing. I have no idea when they're unhappy with me. And I do tell the judge that. I crack that joke. And I say, you know, you're going to have to stop me if you're not happy with me. So I do that right off the bat. And I did do that in this courtroom. He just chose to not believe me. I think that's what happened, is he chose not to believe me until I really forcefully said it. And I think if I hadn't used the word accommodate, so I was shocked, right? I've never had it happen where I've said this and a judge has said, no, Ms. Starr, I want you to stand, right? It's just, and so I was really taken aback.
Are there other questions or comments? No. Oh, there's one over there.
Sorry, but I do have a lot of questions and comments. I was just saying that if they can do this to you, Ms. Starr, Can you imagine what they currently do to a first grader, second grader, and the way their parents are told that their child's disability is disturbing the teacher from teaching the rest of the class?
Yeah.
It's really, it's rampant, it's pervasive, and we really need to have any tool available. And what you said, for example, using the magic word accommodation, sometimes we do need to use these tools. I have a love-hate relationship with the AODA, but I do use it as a tool to educate people, and especially for those who need to understand that they have a right, and their rights need to be, respected. And so it is, and this is what I was asking before, we need to have a bigger campaign on educating, on letting people know we have as much right as anybody else on disability. And I was just going to share that for the last 2 years, a very small group of grassroots people started a march to show Torontonians that we have a body, we have a voice, we are disabled, we're very proud of being disabled people. And so we go from Queen's Park to Ryerson University, and every year has been more and more acceptance, and this fall in October we'll do it again. So you're all invited, and in every day of your life, whatever you do, if you work, if you're a neighbor, be an advocate and support the person with disability. Let's break the attitudinal barrier, which is the most difficult to break.
But you would agree, probably, I mean, I completely get it. It must be tremendously difficult. And every day I count my blessings that I can practice, because 20, 30 years ago, I would no longer be a lawyer. And I'm also privileged because I can buy specialized high-end equipment that many people cannot do to make things work for me. But I agree with you. We have to have global, or not at the national level, provincial level, we have to have big awareness, but there's also small. You really have to reach the individuals who are interacting. You really have to educate them one by one, and know your stuff. If you're a parent, or you're a client, or you're a lawyer, or you're a service provider, educate them individually about every disability, and they will learn.
Melanie, did you want to add anything? Okay, so I'd just like to thank the panel very much for an excellent presentation. Just in wrapping up, I'd like to say that as ARCH is developing and enhancing our private bar referral list in the area of family law and child protection, although it's not an area that we practice in, we do really want to support lawyers who work with people with disabilities in this area. And so we do offer free consultations for lawyers and paralegals who are representing people with disabilities and family law and child protection issues, who have questions about accommodating their clients or how disability law may apply in their case. So please feel free to contact us if you'd like to take advantage of one of those consultations. So I'd now like to invite Ivana Petriconi up to provide some closing remarks.
So just before we break for, my goodness, this beautiful spread there, for some refreshments, it's my job to wrap up and give you just a little summary of the day. I also have some announcements. So firstly, I'd like to tell you about the Disability and Rights for Citizens project, the DRC. The DRC project is a one-year cross-disability initiative that will run educational workshops on the United Nations Convention on the Rights of Persons with Disabilities, and create a series of plain language tools to be distributed to people with disabilities living in Toronto. And the Centre for Independent Living in Toronto, CILT, where Melanie works, is the trustee of the DRC project and is working in partnership with ARCH and the Council of Canadians with Disabilities. The project is funded by the City of Toronto's Access, Equity and Human Rights Fund. So if you'd like to learn more about the project or explore having a workshop presented to your group, there's some flyers like this one at the registration desk, or you can contact SILT and ask for Melanie. If you hadn't noticed already from every one of us from Arch who's been at this microphone, we want to create a robust referral list of lawyers who will help people with disabilities. So please fill out a referral form, and you know, I promise it will be a wonderful relationship with Arch. Just want to, by way of thanking our panelists, tell you a little bit of what I've heard here today. I'm just going to pull out my notes. So from Aisha and Diane, we heard about the duties and the professional obligations that we each have when acting for people with disabilities. We heard about the importance of context to reflect on our own circumstances and biases and how they influence our work. And I want to just take a special moment to thank those panelists who were so generous about their own personal stories to help us understand the context that has brought them to do the work that they do for people with disabilities. We heard about the importance of creating welcoming environments as a legal profession, and how important it is to ask questions of our clients, to treat them with honesty and direct communication. It's important not to forget that race and racism continue to exist in the lives of many people, and that for people with disabilities that can have a heightened impact. From Tess and Tom and Carol, we heard about the challenges and discrimination and often very dire consequences that are faced by people with disabilities, especially people with mental health disabilities in our immigration and refugee system. This is compounded when the person lives in poverty or when trauma has been present. We heard about the need for legal services for people with disabilities, particularly those in detention, and how access to justice can be an enormous gap for those people. We heard about the importance to follow instructions of all clients and to assume that your client has capacity to instruct. And we heard about the difficulties that intersectionality presents, and the good news that the federal court has acknowledged an intersectionality analysis. And from Carrie, and Melanie and Victoria, we heard about the lack of accommodations in child protection matters and the need to fight for accommodation for our clients, the difficult impact that attitudinal barriers have and the harmful stereotypes in child protection matters, especially for people on social assistance. We heard about the difficulty that children with disabilities have and the importance that budgets and linked to disabilities have in terms of getting adequate and appropriate support. I learned for the first time a very interesting observation about the flat affect, and I thank you for that, Victoria, which is another example of discrimination in the ability to parent and other assumptions that are erroneously made about the abilities of people with disabilities. And we learned about good lawyering, preparing your client, and marshaling evidence. These are lessons that apply to all lawyering, not just lawyering for people with disabilities. And I'd just like to conclude the wrap-up by a comment that Victoria made, which I thought was a very poignant one, and that is that we shouldn't bail on these clients. So I'd like to thank the panelists for all of this fine information that we've received today. and make a special request to them to gather here in front of this lovely banner. I love this equity banner. It has a whole bunch of E's all intertwined and interspaced, and anyway, there's a whole bunch of E's there that is really great. So the Law Society would like to take your picture in front of the banner. So if all of the panelists could join us up here, that would be great. I would like to take a special moment to acknowledge the Equity Department of the Law Society. We have a couple of little tokens of appreciation for Rudy Tixon, Jose Bouchard, and Celine Massaroni. You have, as always, our thanks for making this such a lovely event and making it such a pleasure to work with you on our Access Awareness event. And thank all of you for your thoughtful participation, and please join us for some drinks and lots of food. So thank you again.